good afternoon, or if you're joining us from the West Coast, good morning. My name is Sophia Carrillo. I'm an ACS Next Generation leader and the chair of the Los Angeles Lawyers Chapter's Path to the Bench Working Group. On behalf of ACS, I'd like to welcome you to today's conversation on the Mountaintop, Not Yet in the Promised Land, the confirmation of Ketanji Brown Jackson. ACS is the country's foremost progressive legal organization with more than 200 student and lawyer chapters across the nation. Its mission is to shape legal debate, nurture the next generation of lawyers, judges, and advocates, and ensure the law is a force to improve the lives of all people. If you aren't already, I'd encourage you to become a member of ACS. You can go to acslaw.org, where you can join ACS and find out more about upcoming events and opportunities, including this year's National Convention, which will be held June 16th through the 18th in person in Washington, D.C. and virtually. So let's jump right in. We have a lot to celebrate. The Senate confirmed Justice-designate Ketanji Brown Jackson as the next Associate Justice and the first Black woman to serve on the U.S. Supreme Court. Her confirmation fulfills a promise both by President Biden and the Reconstruction Amendments. This is a momentous occasion deserving of celebration. We are so happy to see the legacy that Justice Jackson will have. But in its shadow lurks a danger we cannot ignore, some that we've seen hints during the confirmation hearing, reflected in the racist and rights-depriving rhetoric deployed by some who opposed her confirmation. So today we're going to dig deep. We'll be celebrating her historic confirmation while grappling with the current dysfunction of the confirmation process and the threats to our substantive due process rights, which underpin so many rights: reproductive rights, marriage equality, and a host of personal rights modern Americans take for granted. But as we saw from the confirmation hearings, we may be poised to lose. We'll get started with the conversation with our panelists, and then I'll turn it over to the audience for a Q&A. I will not be checking the chat during our talk, so please hold your questions until the end when we turn it over to the audience. So joining us today for our conversation are our esteemed panelists, starting with Dean Kimberly Mutcherson. She's co-dean and professor of law at Rutgers Law School. Thank you so much for joining us. We have Yvette McGee-Brown, partner at Jones Day, the first African-American female justice on the Ohio Supreme Court. Thank you so much for joining us, Justice Brown. And of course, Senator Russ Feingold, the president of ACS. Thank you again, everybody, for joining us. So let's jump right into it. Yvette, I'm going to lobby this question to you with a little bit of background. So our tone today is celebratory. We're here to really reflect on the importance of this nomination. And when I was thinking about what to bring up when we're looking at how to capture the historic importance of this past week and the years to come of her service on the court, I was struck by her speech at the White House after her confirmation. I'm just going to read a few of her words. She's incredibly a great orator, a great speaker. But at the White House, she quoted Dr. Maya Angelou, and she said that she was there with the White House in the background, excited to join the court. She said, quote, "I do so now while bringing the gifts my ancestors gave. I am the dream and the hope of the slave." Wow. Let's get started. Can you reflect for us on the importance of her confirmation?
You know, it was, it's so empowering. Like everybody I talked to on Friday, we were all just still on such a high from Thursday's vote. I think it's important that she bring that historical context forward, right? Because all of us who stand in these places, we recognize that there were a lot of people who fought to give us the right to be in these places, people who never got to experience the success of all of the labor that they put forward. So when she says, I am my ancestors' greatest hope, you know, I think about my grandmother who was born in Macon, Georgia in 1906. She never got to experience the life that I lived simply because of the time in which she was born. It wasn't that she was any less smart. She just didn't have access to opportunities. And so I think it's important for all of us as we reach these heights that we remember there is still work yet to be done, because as I was looking at Judge Jackson during her confirmation hearings, I kept thinking about where this country would be if we had not put into our law the segregation of an entire race of people for almost 60 years, right? Think about what would have happened if we had made Reconstruction real in 1896 when Plessy versus Ferguson was before the court. So now we have somebody on this bench who so appreciates the history and the ancestors that she brings with her, that I think she will think about not only what the law is today, but the impact of the law as it goes forward. It's a very powerful moment in our constitutional history.
That's a great point. And I think to your point of whether what would have happened if Reconstruction had been made real is one thing that was also jarring was when she was sitting in the room, she was the only Black woman there. And it wasn't until Vice President Harris was physically in the chamber to preside over the vote, was there more than one. And so it was both, her own words speaking about being the first or being the only sometimes in a room, was also shown by her physical presence of being the only one. So thank you for bringing that up. Turn to the other panelists. Any thoughts on the celebratory nature, the historic nature, the importance to Justice Brown's point, what would have happened if Reconstruction was real?
I think that is such a powerful point that Justice Brown just made, and I too think about not just how many people were locked out of opportunity before, but how many people continue to be locked out of opportunity. And my hope is that seeing somebody like now or soon to be, right, Justice Jackson, lights a fire in some folks who otherwise might have thought that this is not a thing that is for me. I've never seen anybody who looks like me who's been on the U.S. Supreme Court. It must not be the kind of thing that I can do. And there's something really wonderful about imagining that there are a bunch of little, Black and brown girls out there who the first Supreme Court justice they'll remember is Justice Jackson.
I would just add, if I could, Sophia, first of all, let me say how honored I am to be on this panel with these co-panelists who have been similar trailblazers in their own fields. And, given my perspective in life, being on the older side, I remember when Thurgood Marshall was appointed. I was a very young guy. I assumed that was just going to be the beginning of a whole lot of that. And it hasn't been, even with regard to African-American men, let alone the idea that I would have almost the entire scope of my life before there would be an African-American woman appointed. And, I'm not as aware of the other panelists, but I'm certainly aware of the role that African-American women have played in this country. It is, the word backbone comes to mind. And to not have that represented in the Supreme Court was just a tragic omission. And yet, I go with Senator Booker's wonderful performance there when he said, you can't take away our joy. People have to understand that when you say the joy, you're talking about the race issue. Let's not pretend it's anything else. That's the joy, that finally we're overcoming that. So I don't need to tell these panelists that. I'm just saying, as somebody that's watched all this is an incredible moment.
Can I add to that? Because I think the senator and the dean they're right on target. I mean, to the dean's point, I had a young Black woman say to me a couple of weeks ago, are we really going to have a Supreme Court justice with dreads? And I said, yes, we are. I mean, think about that powerful imagery there. And then I just have to give a shout out to Senator Booker, because Senator Feingold, you are right. I mean, one of the things he said that I know struck me when I was on the Ohio Supreme Court are those people that work in the building. You know, when he said those people that would come up to him and say, we're so glad to see you. They've worked in that building for 20, 30 years and never seen anybody that looked like her or looked like Senator Booker. That pride, it's almost palpable when those people come up to you and they hug you and they say, we're so happy to see you. So those are two really great points.
Absolutely. And part of the exciting part of this new journey for her is her public role that will be coming up. And Justice Sotomayor has been very active in reaching out to the community and going to public events. And that we're excited to see how Justice Ketanji Brown Jackson will also fill into her own shoes and find her own role. It will be very exciting. So we touched on a couple issues related to diversity on the bench, and we'll get there in depth in a little bit, but I wanted to pose a question to Senator Feingold just about the disrespect and dysfunction of the confirmation hearings. Before this call, I shared with Senator Feingold that to prepare for this talk, I had read all of the Thurgood Marshall confirmation hearing transcripts. And I was hoping that we would play a game where we would go, which of these quotes is from the Thurgood Marshall confirmation process and which of these were from, 1967 versus 2022. But the quotes from this past month were so vitriolic and so intense and so just ridiculous that it was too easy. It was too easy, even though, it was shocking. So I wanted to give a chance for Senator Feingold to lay out, what happened. I think that not many people outside of the legal profession are really tuned into the confirmation hearings beyond the sound bites at the end of the day. So a lot of the public may have missed the kind of questioning that happened and why it was so out of bounds. And I'll give a quick framework and I'll turn it over to you, Senator Feingold, and then sort of the rest of the panelists. But why were the proceedings such an indignity to this historic moment? Well, let's look at history. So when Sandra Day O'Connor was confirmed, it was an easy confirmation, 99-0. Ketanji Brown Jackson was 53-47. And those three votes, it seemed like they were not a certain vote until the very end. Just going to run through some quotes from some of the senators. Trevor Noah actually did a really great video on this where he has senators praising her credentials and her intelligence and then saying they'll vote no regardless. Senator Tom Cotton claimed he couldn't vote in favor of Jackson because she will, quote, coddle criminals and terrorists. Mitch McConnell said, quote, the soft on crime brigade is squarely in Judge Jackson's corner. And when Lindsey Graham was asked why he was not supporting Justice Ketanji Brown Jackson, he said he was proud to share that this was the first SCOTUS nominee he's ever opposed. What's going on? What happened? It seems like, her credentials were untouchable. Did they just decide to burn it all down? These objections seem to have no legs. Can you give us some background based on your experience in the Judiciary Committee? Was this confirmation different? And why so?
Absolutely, Sophia. It was totally different. And, I kept telling people, I felt like I got whiplash because I kept going between euphoria and disgust at this hearing. That my initial euphoria was not only her wonderful opening statement, but, they just gave up on pretending she wasn't qualified. I don't know if you noticed that. That was what Fox News was trying to do. That was just a joke. They couldn't even move with it. So I was sort of euphoric about that. But then they proceeded to use every rude technique that I've never seen before. Look, I was in the Senate for 6 Supreme Court nominations. For 4 of them, I was on the Judiciary Committee. So I was one of the people asking the questions and meeting privately with them. 2 of those were under George Bush and 2 were under Obama. So it was all the different politics. And you're right, Sophia, you can go back to Thurgood Marshall or you can go to those hearings. There was never this kind of rudeness I mean, to me, it was unbelievably condescending toward her. They often wouldn't let her answer, saying that she was filibustering, and she said about 6 words. So frankly, it made me angry because I never treated anyone like that. I don't believe anyone should be treated like that, especially somebody as good as this. And what's even worse is they knew she was going to get confirmed. And what they were doing was just setting up a play for race-based dog whistle politics for November. It wasn't even about really her confirmation. And so it was cynical. It was disrespectful to the process, disrespectful to the Constitution's idea that the president nominates and the Senate gives advice and consent. And so from every point of view, it was wrong. And let me just sort of finish with this. These senators that acted like this, some of them weren't as bad. Some of them were the top law students at our top law schools in America. They're like first or second in their class. How do you come out of Harvard or Yale Law School and come out of there as a lawyer and act like that towards somebody who's about to become a justice for life? To me, that, people should be ashamed of themselves. So obviously I'm passionate about it. Sophia, it was totally different.
Great. And so I want to turn it to the other panelists, and I will flag that my next question after reflecting on what happened at the confirmation hearings and the attacks, is what did the attacks mean? So we're going in that direction next.
Well, I have very, very strong feelings about what happened at the confirmation hearings. And, on one hand, I think that for a lot of us, particularly as Black women, we understood that she wouldn't necessarily be treated the same way that other nominees had been treated. And I was sort of prepared for that. I was not prepared for the level of foolishness to which people sank, which was really not just unfair to her, but unfair to us and unfair to the Senate as an institution, quite frankly. The other thing that really bothered me about that is that, and Senator Feingold suggested, this idea of kind of having whiplash. And I think another part of that whiplash was, on one hand, that sort of joy and excitement that she was there and that she's amazing and, her credentials are impeccable. But I also worry about the folks who had to watch that happen on TV and the ways in which that might actually discourage some people from wanting to climb the ladder, right? Why should you want to be in a room where people will show you that kind of disrespect, and particularly that kind of disrespect to somebody who, 2 Harvard degrees, Supreme Court clerkship, federal public defender, right? There's nothing about her that you could say that she wasn't deeply, deeply qualified. The other thing that I want to say, 2 other things, and I promise I'll be quick about them. One is the importance of who is in the room. One of the things that I thought was so wonderful about the speech that Senator Booker did, which is absolutely one for the history books, right? We'll still be talking about that many, many years from now. But what I liked about it was, one, he was a person who recognized what it felt like to be a first, to be an only. And he took that moment not just to raise her up and raise the rest of us up and to talk about the joy of the moment, but also to give her a break, right? Because when you've been in that kind of situation, having somebody in the room who says, I see you, and I know that what's going on here is completely unacceptable and completely unfair, and I want to acknowledge that, and I want to give you a moment to step back from the hours and hours of awful treatment that you have been receiving. And Senator Padilla did something very similar, and when he had an opportunity to speak. And then the last thing that I want to say is, and this goes back to Senator Feingold's point about, people like Senator Hawley and Senator Cruz, people who know better. And by that, I mean, people who, are accusing her of calling the president a war criminal. You understand how a caption works, right? You know that when the president changes, then the caption's going to change as well, right? Or Senator Hawley making all of these claims about her coddling, child sex predators, and, who does that? And, you have to be a terrible person. and really feeding into these conspiracy theories that we know some people use to engage in violence. So not just making her look like a bad person or attempting to make her look like a bad person, but literally putting her physically at risk by making these arguments that feed into these conspiracy theories that he knows were inaccurate. Right. And that's the piece that really, really gets to me, because these are not people who are talking out of ignorance. They know exactly what they're doing. They know exactly the ways in which they are wrong. And yet they're willing to stand in the Senate in front of cameras and the world and say these things. It was deeply, deeply disappointing, to say the least.
Absolutely. And that's a terrific point of the detail of how this was different. And I think that the Strict Scrutiny podcast in their recent episode, Backwards and in High Heels, explained, I watched the confirmation hearings and I didn't catch this, but Senator Cruz is actually one of her Harvard Law classmates, and he essentially doxed her. He shared her children's school, something that is, incredibly dangerous to do, especially in this moment, especially when, they are accusing her of things that are dog whistles to fringe groups, to, as has been discussed before, many different groups, and they're aware of these dangers. And so that was very striking, has not gotten as much, I think, press. Your point, you brought it up. Strict Scrutiny podcast brought it up, and it's not getting talked about enough. And there are people in the room who knew better and knew what their attacks were doing. And so, I really want to pause on your point about what people watching the confirmation hearings must have felt, because there is that, the joy of having someone who is, a young girl or someone who's aspiring to go to law school, or even kids, right? I was a teenager when Sotomayor was confirmed, and I can tell you that your predictions about pride and, seeing someone who looks like you and they are, on the mountaintop, it's true. I've talked to people before about, because she did, you see the path. And this is why this confirmation is so exciting, because there is now a group of people who, I'm sure are incredibly, aspirational, I'm sure are very driven, ambitious, ready, but that wind at your back when you need it most in law school, when you have to, really, you're in the trenches. Going through law school is not a short-term endeavor, and especially for disadvantaged groups and for underrepresented minorities, it's a commitment that you have to make when you're probably a teenager, that you're going to go to as good a college you can, you're going to take the LSATs, maybe work, go through all of that, the bar. So it's really, I want to just add a cap on that point, that it's not just people saying, I see her and it's possible, but it's really the pipeline to the legal profession is so long and so deep, and having her there is going to open that for so many more people. At the same time, there are a constituent group who watch the confirmation hearings and are going to say, senators, you did not protect her well enough. Cory Booker did, Amy Klobuchar at the end did, she's not on the committee, but, Padilla did in some instances. But it was still both that joy and disappointment. So thank you for sharing that. And then Justice Brown, did you want to add anything onto that? Our next topic, just to preview, is, what do the attacks mean? And what does that magnifying glass of the committee mean when it says, who's worthy to be a judge?
So yeah, I was going to follow the dean's comments, but I think my comments feed right into your next topic, and that is this. In addition to the disrespect to Judge Jackson, it also will have a chilling effect, I think, on the judges who are in our courts, the decisions they make. What concerned me was I kept hearing them talk about these 7 cases where she was in the norm. She was in the majority of judges who did not follow the sentencing guidelines, because the Congress has failed to keep up with technology and how it relates to the charge of disseminating child pornography. She was in the majority of judges who do that. But my concern is that any judge wanting to get confirmed to a circuit court or the Supreme Court now is going to think about their decisions. We don't want judges gaming their future when they're deciding individual cases. And what struck me is that for anybody who thinks, oh, one day I might have a confirmation hearing, ooh, I better make sure that I'm tough on crime. I'm the strongest judge there, so I don't get hit with that. That is wrong in a constitutional democracy. I also have concerns about how they kept hitting her with being a federal public defender, hitting her for having represented somebody at Guantanamo Bay. Our system is built on prosecutors and defense attorneys. One should not be more noble than the other, and we should applaud somebody who chooses to go and be a public defender with less resources, more cases, protecting the constitutional rights of people who are alleged, and we have to remember, alleged to have committed crimes. And so the whole tenor of the proceedings, for me, causes me concern about who will choose to do the work that needs to be done to uphold our constitutional democracy.
Wow, you took all the points there. That's right. And it was very striking that the barriers that public defenders face have only been made more difficult because of this confirmation hearing. Public defenders, civil rights attorneys, they're public interest lawyers, they're public servants. And what we saw for the confirmation hearings is we're going to look through your record, and instead of saying you go to bat for people's constitutional rights every single day, we're going to cherry pick and say you coddled terrorists, or you are soft on crime, or you are pro child sex abuse. And that's just, from the people who know better, who know how our system works, that there's, prosecutor on one side and a defender on the other, public defender or private defense attorney. It was just shocking. And so I wanted to.
Can I add one thing to that before we move on, Sophia?
Sure.
I want to totally agree with everything that the justice said. And, one of the things that I've heard a public defender say before, and I just love this so much, is that they're not just representing their clients, they're representing the Constitution, right? And if you believe in our Constitution, you should be proud that people are public defenders and take these jobs. But the other piece to that is, any position that claims that our system of criminal justice is somehow infallible, right? If somebody gets convicted, then we know that they're a terrible person who's done terrible things. We know that to not be true, right? We know about the disparate sentencing. We know about the, racism in policing. We know about people, not having access to enough in terms of resources when it comes to being in a criminal case. And so the idea, right? I mean, we saw this in another confirmation hearing for another judge who had worked on innocence cases. Innocence cases are about people who are convicted for crimes they did not commit. If you're going to call somebody like that soft on crime, then you just don't care about the criminal justice system at all, right? You're just happy to see people locked up with no reason.
Right. That's a fabulous point. And I just want to add one last thing here before we turn to some of the issues about diversity on the bench that we saw from the confirmation hearing. But with my, path to the bench hat on, I just want to reiterate that it seems like the attacks on her record as a public defender, and she was in the appellate level too. So she was really going for constitutional rights. That is a phenomenal job. And we should be incredibly proud that she was representing the United States, our Constitution, in addition to her, her clients. But we saw there that there is, attacks on her specific record, not just as a public defender and at the Sentencing Commission, but as a judge. So tying that to Justice Brown's point about we don't want judges looking over their shoulders and saying, is this going to come up later? Or even if they don't have aspirations for future judicial appointment, just, the public attack, because these are very public proceedings, and the sound bites that come out of it, reflect that, that these are concerns of the senators. So just want to end that with, I think that this issue has created the public attention to this And some of these false flags have created real issues for candidates and nominees who we should be excited about. We should be excited to support public defenders. We should be excited that after 4 years to support civil rights lawyers who protected our Constitution, who went out on a limb, and we should not be asking lawyers or judges to look behind their back and say, is what I did, should I be careful about what I say? Should I be careful about what I do? When we ask people to protect our Constitution, we want them to do it with full force and vigor. And so I'm, glad that she made it across, and that we can look back and say these attacks were, jokes, but it's a serious consequence to the public perception who don't know how our system works or how the balances work between, a public defender and the US government bringing a case. So I'm going to turn to the issues of diversity on the bench. It's come up in our conversations. When looking at the confirmation hearings, I recalled Judge Carlton Reeves' 2019 speech to the University of Virginia called "Defending the Judiciary, a Call for Justice, Truth, and Diversity on the Bench." Judge Reeves is a district court judge in Mississippi. And he was explaining that the third attack on the judiciary has been the narrow set of perspectives. And when we have such a narrow set of perspectives, what truth will be overlooked? He quoted Oliver Wendell Holmes about the experience of, the life of the law is experience. And so we have here, our first confirmation of a Black female Supreme Court justice. And we have the possibility to really analyze our federal courts and our state courts too. I'm in California, and the last time that we were ranked for diversity on the bench, we got a D in California. Now, Secretary Cespedes is doing a great job to change that, but this is really an opportunity to look at the courts, federal courts, state courts, and say, we're lacking. All of the diversity numbers are pretty bleak. I think the last set I saw that ran last week said that something over 80% of the federal bench is white and male. So can we talk a little bit about how essential it is that for our democracy, for our judiciary to reflect the life of the law, their lived experience?
I'll start, I guess. It's hugely important. I mean, part of the issue is, particularly as you start to look at the federal court, there's this whole pipeline that, at least as a law student of color, when I was in law school, I didn't even know existed, right? You got a clerk for the right judge, so that judge then gets you as a feeder to the right circuit court judge, who maybe then, if you want to go to Supreme Court, you get there. So a lot of who gets selected for federal judges depends on who they clerked for, who they know, because again, it's a presidential appointment or it's your senators. If you're in a state court, though, often you have to run for election. And if you're a diverse judge, running for election in a state can be pretty daunting, and getting elected, depending on which state you're in. In Ohio, the only Black judges we have are in our urban counties. We have over 700 judges in the state of Ohio. And I think the last statistic, less than 3% are Black judges, because you just don't have Black lawyers or Hispanic lawyers outside of your urban counties running for judge, because their chances of getting elected are so small. So one of the things we have to do is create opportunities by, one, educating the public about what judges do, creating the infrastructure that allows talented people who want to be jurists to run for judge, and demystify the system somewhat. I mean, I was the first Black trial court judge in Columbus, Ohio. I mean, that was in 1992. I'm dating myself here, but think about that. It was 1992. I mean, it's not like it was 1960. And so, sorry, my camera fell. And so we still have a ways to go here in terms of making sure that there's access.
Yeah, sometimes when I think about this diversity issue, of course, a lot of it has to do with the public way it looks and how awful it is if there's only people of one background. But it's also one thing I think about is what happens, within the court. If there aren't other kinds of people there, just the process. Of course, in the United States Supreme Court, you can't have every kind of person represented at all times, but we all know that not only do they appear on that bench in front of everybody, but they go back into the conference. and there's 9 people in there. And if there's nobody in there who's racially diverse, who has never grown up with people that look different than them, who has never sort of been on the other side of a lawsuit where you're representing a union or a plaintiff or a consumer, the reality is it can't possibly be a full and thorough and appropriate discussion, as the other panelists have pointed out. So the actual product, the work product that comes out of there is flawed because it doesn't really have the full context. And I think that's one thing people have to realize what we're talking about here. I even go a little bit farther. I think, look, this justice is going to be fabulous, but she happens to also be one of these people from, not originally, but from the Ivy League schools, and a judge. So, the Supreme Court is almost all people that have been Court of Appeals judges now, and that's good. But there are a variety of things that people can do in their life and be good judges. And like, Governor Warren, he was a politician. And, I'm a politician, so I kind of got a thing for politicians. But, having people who have different experiences to balance what's going on in the room. And right now, the court is pretty narrow. She's going to make a very positive difference because of her nature, her personality, and the range of experience she had. But yeah, that is all necessary to produce a justice that is really something that involves all people's viewpoints.
Great. And so I'm going to turn to Dean Mutcherson now to discuss what the confirmation hearings showed us about the challenges on the horizon. So I'm going to give a little bit of background for our listeners. So part of the confirmation hearing that most Americans probably didn't watch or wasn't covered by the news was a line of troubling questions that signaled continued attacks on substantive due process. So by way of background, right now, Roe v. Wade is being directly challenged before the Supreme Court in the case Dobbs v. Jackson Women's Health Organization. And there's general consensus that there's a good chance Roe may be overturned. With Roe on shaky ground, it seems like we're seeing a challenge to over a century of Supreme Court precedents that recognize the 14th Amendment protects fundamental rights, including ones that aren't specifically mentioned in the Constitution's text. And so in the confirmation hearings, there were several lines of questioning about, so Senator Cornyn asked, well, marriage, the word marriage isn't in the Constitution. That kind of line of questioning suggests that, these issues that rely on due process clause of the 14th Amendment are on the chopping block. So for example, right to abortion in Roe, legalization of same-sex marriage in Obergefell, right to birth control in Griswold v. Connecticut, and criminalization of anti-sodomy laws in Lawrence v. Texas. So my question to you, did that line of questioning scare you? Do you think that they were signaling that, these issues are up for grabs? What was going on? And can you give us a little bit of context of what was happening there?
Sure. Well, I want to say one other thing first in response to the last question, which is one of the other pieces that's really frustrating that we see happen all the time is this assumption that if you're a white man, you have you're able to just be objective, right? That you're just walking into a space and you're just looking at everything that's happening and then making a decision. Whereas if you're a woman, if you're a person of color, then you're walking with an agenda, right? And you can't just sort of look at the facts and make a decision. And we saw that happen with Justice Sotomayor. Remember the whole wise Latina that she, the comment that she made in a speech once, and that came out. And then also, sort of treating Justice Jackson as though, it wouldn't be possible for her to think beyond the fact that she's a Black woman, which is wholly offensive on a million different levels. But anyway, so moving on to your question. So I'm a reproductive justice scholar. The work that I do is around issues of reproduction and parenting. And so everything that's been happening at the Supreme Court is very much a part of what I've been thinking about and, talking to other folks about for quite some time now. And the issue of sort of privacy and substantive due process being on the chopping block certainly didn't start with Dobbs, right? I mean, this has been a sustained campaign. We have a number of justices on the court who have been very clear that they think that the court overstepped in a number of different cases that involve privacy, not just abortion cases. And we saw it in the Dobbs oral argument, right? One of the lines of questioning that actually Justice Sotomayor had for the Solicitor General from Mississippi was, all right, if Roe falls, what's next? And the SG basically said, oh, no, all those other rights, they're totally protected. They're very clear. Nothing's going to happen there. And yet, if you look at the amicus briefs, several of them in that case are very clear that Roe is a starting point, not an end point. So the truth of the matter is, and this is another reason why this sort of the willingness to be on the wrong side of history in this case was very confusing to me. Justice Jackson's not going to make a difference. It's a 6-3 court. So what she might be doing is, joining with Justice Sotomayor, who's sort of the queen of the great dissents these days, that she might be doing a lot of that work. But, there aren't enough folks on the court to really swing things any to the middle or to the left, right? So I think that we're in for a really, really bumpy ride. And I think what people need to be really conscious of is whatever you think about abortion, if you think contraception is important, if you think people being able to marry not just somebody of the same sex, but somebody of a different race, right? Loving versus Virginia is potentially on the chopping block, right? I mean, those are things that we should really be thinking about. And be really wary of, right? What does it mean when we push all of those things down to the states, particularly at a time when we are continuing to see this huge groundswell of voter suppression laws? What is that going to look like when the Supreme Court says, we're no longer in the business of protecting privacy rights, we're going to just leave it to the states? A lot of people are going to find themselves without rights that they thought were given.
I would key off of that a bit. One of the least offensive of the group maybe was Senator John N. Kennedy from Louisiana. But the truth is he was sort of lecturing to her like she was his law student. And I just make that comment because he was saying, now, Judge, if it's a right, shouldn't that just be something that people should decide? What do you mean? The whole idea behind a right is that the people by a majority vote can't decide to take it away from you. And so the one thing you can be sure of is when you have that kind of a coordinated attack, it's not like a few senators got together and said, why don't we try to see how this goes? This has been planned for a long time by the Federalist Society, by the billionaires. They want to take substantive due process apart, just as the dean was suggested, so they can get rid of same-sex marriage, so they can get rid of interracial marriage, so they can get rid of the right to contraception and all of those issues. And then they say that the Ninth Amendment, the only time you can recognize a right under the Ninth Amendment is when it's explicit, or that the people should somehow have a vote in Alabama whether or not this right should be allowed. That's ridiculous if you believe in rights. And yet the one problem they have now is that they're telling us, but that means they're ready. They wouldn't be telling us this if they weren't ready to do all this stuff. And so I think the warnings we're getting from the other panelists are absolutely right and very troubling.
I mean, the senator and Dean, you are directly on point. I mean, this is a strategy, and it's because they're becoming a shrinking majority. And so rather than having the fight for ideas, they're playing chess, right? And most of us are just kind of, oh, look over here, look over here. I mean, somebody said to me, and this is so true, like everybody was talking about Will and Jada instead of Clarence and Jenny. We need to start being smarter and paying attention to what's going on in this country. Look at voting rights. The court has sent this signal that, oh no, the federal court shouldn't be involved in voting cases. And so now they're pushing that down to the states, and Ohio is now on their 4th map. I mean, we've got Florida. We've got the governor of Florida wanting to sue his own legislature because they didn't gerrymander enough. So what we've got to do, ladies and gentlemen, is understand that the game is changing. They are not hiding. They are telling us, and we've got to make sure that all of us are fighting for this constitutional democracy. We are a country of laws. We cannot allow that to be taken away by thinking, oh, this is just about abortion. No, it is not just about abortion.
Wow. Yeah. Well, thank you all for weighing in on that. It's really quite terrifying. And I think we just want to wrap that point with saying that, part of it is also public education and explaining to non-lawyers and society at large about what these questions mean and what it means that we're heading down this path. And I think it was one law professor, and I'm sorry to not have their name handy, I'm going to quote their quote that said, I think it was in the New York Times, about, explaining, it wasn't just explaining substantive due process, but explaining the idea and rejecting the idea that if the word's not in the Constitution, it doesn't apply, right? Which I'm going to shout out one of my LA Lawyers Chapter colleagues, Connor Tucker, wrote a little something on the ACS blog about the using originalism as a weapon, right? A textualism as a weapon. But there are so many rights not enumerated in the Constitution, and one way to really push back is to show how ridiculous it would be if there were, well, that's not in the Constitution. Well, public education, the law professor said public education isn't in the Constitution. The words aren't there. Are we going to go down the road of challenging Brown v. Board? And so that's, one thing to think about. As we're aware of these issues coming down the pipeline, how do we push back and how do we say, well, that's not workable. That's not what the Constitution is. And that's not what rights are. We don't get to decide to roll back rights. So I'm going to turn to our last question before I turn it to the audience. The promised land. So the KBJ legacy on the bench and the next generation to come. So many are looking forward to Justice Jackson's judicial legacy playing out on the court, hopefully for many decades. Not just her time on the court and whether she will, join Sotomayor or bring her own voice and as a great dissenter, hopefully on some Fourth Amendment issues and other constitutional rights. But what will her role be in society? What will her impact be for larger society to have her on that court? And I'm going to just end on a celebratory tone as we hear everybody's parting words. Since our panel is named after Dr. King's I've Been to the Mountaintop speech, let's give his words today a second read, which take renewed meaning given the challenges we face today and the hope that we have for Justice Jackson. So he said, let us rise up tonight with greater readiness, let us stand with greater determination, and let us move on in these powerful days. These days of challenge to make America what it ought to be. We have an opportunity to make America a better nation. So turning to the panelists' final words, final thoughts, after 233 years of its existence, the Supreme Court will soon have its first Black female justice, Ketanji Brown Jackson. Final thoughts, no pressure, her legacy, what her confirmation means for American society, and what is next to come.
I don't think we know what her legacy will be defined by her, right? I think one of the things is that I will be enormously proud that she is our first Black woman on the United States Supreme Court. I think Senator Feingold brings up a good point that there has to be a place for those of us who graduate from public law schools to someday be on the court. But for right now, just like with President Obama, she has every credential that anybody could ask. You cannot assail her qualifications. For your first, you want that person that is uber qualified. She brings every intellectual check mark you could want, in addition to the Sentencing Commission, in addition to being a federal public defender and being in a law firm. She's got it all covered. So for that, she makes me enormously proud. I can't wait to see. I think her legacy is going to be one of being thoroughly prepared. She's going to use her pen and her brain to combat the majority when she has to, and she's going to be unafraid to use her voice to speak for what's right, to uphold the Constitution. That's what I think.
I guess I would only guess, but my sense is that more than anyone else possibly, she will remember that the Supreme Court is from a constitution that is for the people. And that includes the court. It's not like there's the people and then there's the court. That's what it's there for. And my sense is that as brilliant as she will be, is that she's going to bring an element of humanity to the law that is unusually strong and important, and that people will be able to relate to. So I'm certainly looking forward to that.
I'm incredibly excited as well. And, you know, I think about you, we started by talking about the ceremony at the White House and how powerful it was, the sort of symbolism of that. But a piece of that symbolism is that she was standing in front of a White House that was built in part by the labor of enslaved people, right? And then there she is standing as a Supreme Court justice. That's an incredibly powerful statement about what this country is, it can do, right, when it chooses to do so. And I just think that's an important lesson for all of us, because sometimes I think we can all get a little depressed about where we are and where we're going. And so those moments are really, really key. But the other thing that I think is really key, you know, as somebody who is at a law school and a law school that educates a lot of first generation students, so many of our students of color come to us and say, I never met a lawyer before, or I've never met a lawyer who looked like me until I came to law school. And I think that Justice Jackson's going to be one of those people. I mean, I did a visit at a third grade classroom in Camden, New Jersey, not so long ago, because I wanted those 8 and 9-year-olds to be able to say, I met a Black woman who's a lawyer and a law dean. And I think she's going to be a person who's willing to go out into the world and have those little kids who look and say, oh, geez, right? Like that is a path that I can walk. And I just think that the power of that is we can't even count it, right? It's just so enormous.
I just got chills. Well, so I'm looking at the Q&A right now, and I think we actually touched on a lot of what has been pulled up. So I'm going to give the audience about 30 seconds to drop any more questions in the Q&A. And I will look through these and try to do a rapid fire kind of question that will contain them all. So if you're listening, you have 30 seconds to put your question in the Q&A. Let's get started with one of them that follows up on unwinding substantive due process. So Dean Mutcherson, this is for you and for everyone else. Someone asked, what will the impact be on people's daily lives? Is there any reason to believe this court, as currently constituted, won't go down this path? So 6-3 court, what are your predictions?
I don't think there's any reason to think that the court is not going to go down that path to the extent that they can. In terms of abortion rights, I think we already see in Texas what it looks like when you unwind that right. And it is women and other pregnant people traveling hundreds of miles to terminate pregnancies. It is women being arrested for miscarriages. That is certainly in our future. But beyond that, I really do think what we need to keep our eye on is what are the next targets, right? So contraception is 100% going to be targeted, and we've already seen that in the context of religious rights. So we'll see that happening. So I really think that what people need to be very conscientious about is recognizing that the Supreme Court, if you're on the left, the Supreme Court is not going to be your friend for many, many years to come. And so if there are things that you want to achieve, you need to really start focusing on your state. You need to start focusing on your state legislature. You need to start focusing on your state courts. You need to start thinking about proactive legislation, because that's the only way that we're going to be able to maintain. And certainly in the context of reproductive rights, I'll just say, I'm in New Jersey, make whatever jokes you want to about the state of New Jersey, but New Jersey just passed the Reproductive Freedom Act, which is actually protecting both right to abortion and right to access to contraception, and creating funding mechanisms for those things. So that can be done anywhere and everywhere if you get the right coalition together.
Thank you for sharing that. And it's so important to echo your point about people looking to the states and looking to how they can still push for rights, push for change, push for progress at the state level.
Right.
And
Know your state constitution.
there we
Because
go.
state
Yes.
constitutions are often much broader than the federal constitution and specific.
Great. So let's take another look at the questions. I think we are right on time. So we've talked a lot today.
Can I add one thing before we go?
Sure.
And I just want to make sure everybody remembers, because I love this about Judge Jackson. I don't know that we gave enough attention to it. Remember that it was her chairing the Sentencing Commission that got the retroactivity application of crack cocaine and powder cocaine. And I just want to say that because remember when President Obama called on law firms to represent people, there are hundreds of kids who got at 20 or 25 draconian sentences that Judge Jackson, as chair of the Sentencing Commission, had those new laws applied retroactively and got those young people out of prison. So she has done a lot, not just as a judge, but even before. And we need to remember that, and to echo what the dean said about state constitutions. Get out and vote. That's the only way we change this.
That's phenomenal. I had no idea that she was involved with that. Thank you for bringing that up. All right, Senator Feingold. So do you have any parting thoughts?
Well, you know, I certainly don't want to be at all a downer, but I think everybody has to watch what's going to happen later this year with these elections, and that they're trying to set up the same play that was played in 1968 by Richard Nixon after what were called race riots, Watts, and the assassination of Martin Luther King. You know, law and order. And then in 1988, George Bush, Willie Horton ad to try to beat Mike Dukakis. And these hearings were a similar attempt to link race and crime. And of course, in this case, it's taking the George Floyd tragedy, Black Lives Matter, and claiming that this is a unleashing of an enormous wave of crime that is related to race. And we just have to have our eyes open on that is what they're doing. In addition to all the joy that I definitely feel, we all feel this has been a marvelous panel, but we do have to face this in the next few months.
So I think we'll end there. We have a lot to celebrate. We have a lot of work around the corner, a lot to educate the public on, and to, protect Ketanji Brown Jackson's legacy and explain to the public, what happened with the confirmation hearing, what happened in this moment, and what's next. So thank you again, Dean Mutcherson, for your excellent commentary and ideas about, people looking at state constitutions and looking at protecting your rights at the state level. Thank you again to Justice Brown. It was so beautiful to hear your perspective, and I will never forget how you explained, your own experience on the court, but also thinking of the impact that Ketanji Brown Jackson will have. And Senator Feingold, thank you for your expertise in explaining about how the judiciary functions, how committee functions, how it should have functioned, and what went wrong here. Thanks for joining us, everyone. Have a great rest of your day.
Thank you.
Thank you.